Recently, an interesting hearing took place on a public interest litigation petition in Supreme Court of India, and the petition was seeking the enforcement of right to education under RTE Act in the educational institutions run by notified minorities. The petition prayed for the enforcement of Section 12C of the Right to Education Act, highlighting the issue of withdrawal of the pre-matric scholarship scheme for minorities. Actually, at this point of time, it is pertinent for us to see what Section 12(1)(c) of Right to Education Act states. It states as non-minority private unaided schools to keep aside at least 25% of their entry-level seats for students belonging to weaker sections of society. So here the point is, under right to education, when this PIL was filed, it was only taken for the benefit and interest of minority students. But the section 12(1)(c) under RTE Act states that it is for weaker sections. So there was an interesting question from the bench to the bar, and the question was why this was specifically taken only for minorities and why it's not taken for all at large. Because when you take the cause only for minorities, it gets colored for specific religions. But weaker sections are not restricted to one just minority religion or other. That's where the right question asked by bench at that point of time was, the weaker section entry level seats must be for all people across all religions in India, whoever belongs to weaker sections. But when the prayer was made for a particular religion, the bench rightly observed and said that religion is important in our country only when it's relevant under the law. Otherwise, for all purposes, India is a secular country. All religions are one and the same. So the weaker sections belonging to any religion are weaker sections only. Hence, the petition was dismissed. So the basic crux that we need to know from this verdict is that when we fight for rights which are common to all, then it need not be specifically pleaded only for a particular religion. Such kind of rights cannot exclusively be prayed for one particular religion because such rights are common to all religions. That's the reason in India we need to have the inclusiveness of all religions instead of one trying to fight for one particular religion to meet their specific needs by leaving aside other vast majority religions and their people, where even the weaker sections among them are also very high in number. That's where kudos to the bench, which has rightly observed that religion is important, when it is relevant under the law. Otherwise, we are a secular nation. Everything we do, we have to imbibe that spirit, both citizens and the state. And I really appreciate the kind of message that has been spread, and I feel this is a great verdict from the bench. Thank you very much.